Welcome back to Casual Friday at Florida Criminal Law TV. My name is Stephen Cobb, the host of Florida Criminal Law TV since the 1990s, and I'm really enjoying answering viewer questions today and people who also read things on the website who followed my videos. I'm very grateful. Thank you very much. And so let's go to the next question in the series because I've run into this question since the very beginning of my career, and it led to a creation of the top 10 defenses that will not work. And we're going to cover one of those 10 by answering this question. So a viewer writes a very good question, and the question is simply this. I don't like my plea bargain. Should I go to trial? Now, a lot of people believe that if you don't like your plea bargain, you set your case for trial. Some lawyers believe this, and magically on the day of trial, the plea bargain is going to get better. Here's the truth. Yes, that is true in some cases. What also can happen is it can blow up in your face like a thermonuclear bomb and destroy your life. Because one of the top 10 defenses that will not work is, that's too much time, or I don't like the plea bargain, I'm going to trial. Now, can you imagine me standing in front of a jury with a straight face going, ladies and gentlemen, our defense is simple. Although my client is guilty, that's too much time and you should find him not guilty. No, that will not work. That will only result in a conviction. And I'll give you an example of where that applies. There was a guy who had a 4-year probation offer on the table, was standing in front of the judge. A colleague of mine was handling the case. And because his mind wasn't in the right place, at the last second he said the wrong thing in court. He came back the following Monday after the judge left it set for trial, tried to enter a plea of no contest, this time succeeded, and traded 4 years of probation for 35 years in prison. Now, I don't have a degree in math. I have degrees in things like electronics technology, computers, history, my doctorates in law. That's 4 degrees. That's plenty. But I don't have one in math, yet I can figure out, just like you can, that 4, whether it's years in prison or probation, is a smaller number than 35. So often we run into cases where people will say, my friend said that if I just leave it set for trial, I'll get a plea offer on Monday. Well, is the gentleman who tried to enter a plea and was not successful in doing so, discovered that 35 is a bigger number than 4 years of probation, you don't want to blindly and recklessly reject a plea offer and go to trial if your lawyer advises against it. Now, notice that qualifier if someone on your legal team who is a lawyer recommends against it. Because when you're experienced in the criminal justice system, you know when you're looking at a file, you go, okay, based on this, and this, we should leave it set for trial because I believe they're going to fold on Monday because we've got this defense, that element has a problem, there's a risk to them on this other element of the charge and the jury instructions. In this particular case, I believe we should leave it set for trial. However, that is a judgment call on tactics and strategy that you are not qualified to make. I mean, let's look at the reality. Have you been to 3 years of law school? No. Do you have a specialization in criminal law? No. Do you have experience litigating criminal defense cases as a lawyer, not as a defendant with a long prior record? And we know the answer to that question is, again, no. So you don't just blanketly answer a question yes or no like that. If I don't like the plea offer, should I go to trial? Yes or no in every case. The answer is you listen to your legal team, and for the love of God, please do not go to the internet and do what so many people do. They're going to research the law and research the law and research the law and bring these cases to their lawyer and tell them they must do this and they must do that because you don't know how to research the law. Just because you can put things into Google, just because you were a legal secretary for 5 years, just because your next friend's best friend's neighbor's dog's former owner was a police officer in Chicago does not mean that they know how to handle a major decision like that. This is a critical decision, the decision whether or not to accept or reject a plea offer and go to trial or not. And that is something that if you are the defendant, that you make. It is not something that the lawyer makes as a final decision. However, as a matter of tactics, as a matter of case strategy, your lawyer is going to advise you, and here's my advice. Follow their advice. They have experience. They know what they're doing. They've actually tried criminal cases, unless you've gone out and, picked somebody whose main focus in life is real estate and family law. Oh, occasionally they do criminal law. Avoid that person. Get somebody who does criminal law exclusively, or so frequently they know what they're doing. Because when they give you advice on whether or not to take a plea bargain, they are basing it upon actual experience. No one wants to hear, in 27 years of experience that I've had, that, for example, 12.1 months in state prison is a good deal. But you know what? If you've got a long prior record, a terrible case, and you've got a year and a day kind of an offer, and then your case is over with, and the downside of your case is if you lose, you get 3 consecutive 15-year sentences for a total of 45. It again is basic things we saw on Sesame Street and other shows as children. Which one of these numbers is bigger than the other? And so for a question like this, yes, as a defendant, it's going to be your choice as to whether or not to take a plea bargain, but whether or not it is advisable or smart to go to trial instead, that is something where you make that decision after you've had a lot of input and discussion with your legal team.